Hi, everybody. Welcome back to our new year of our webinars. This is our first webinar that we are starting off for this year, for this fall. I hope everybody had a wonderful summer and welcome back to our yearly webinar series. And I hope that you have joined us in the past and that you've had a chance to kind of enjoy some of the webinars that we have done. If you haven't, you can find them on our YouTube, EFNE YouTube channel. We have all of our webinars saved up there. But tonight is a topic that is near and dear to my heart. I'm really happy to be introducing our tonight's speaker. I know a lot of you know who I am. I'm Christine Bennett, the Community Education Manager. I have a daughter with epilepsy and who this topic is definitely something that we need to be paying attention to because she just turned 18. So we're right there. Yeah, Janice, we're nodding. We're like, yep, I gotcha. Completely understand, right? Yes, it's not a territory that we want to have to venture in, but it's something that we need to think about. And Annette is here tonight to kind of share, and I'm happy to be going ahead and allowing her to um, kind of tell her story and kind of be able to um, kind of tell us a little bit more. So I am going to go ahead and just read a little bit about who she is, then I'll hand it right over to Annette. Um, so she's the founder of Special Needs Law Group and Special Needs Family Services. Annette Hines brings personal experience with special needs to her work as the mother of two daughters, one who have passed away from mitochondrial disease in November 2013. Um, that hits hard for me, Annette, because my daughter has mitochondrial disease.
Mhm.
Um, Annette knows firsthand just how complex and overwhelming the legal systems and processes are for parents of children with special needs. Amidst the grief of losing her beloved Elizabeth, Annette realized that life was giving her a second chance to use her extensive legal expertise to help families who are going through the same challenges she's faced. So she's going to go ahead and make a presentation for special needs planning, and she'll go ahead and answer any questions afterwards, but you're more than welcome just to put them in the chat. If you don't feel comfortable asking them, I'm happy to read them for you. When it's your turn for your question, I can just call your name and you can unmute yourself and be able to ask Annette those questions. But if you can keep yourself on mute until the question time, just so that everybody can hear, that would be great. She also wants to note that Attorney Hines will provide advice and not legal counsel during this forum. So I do want to kind of say that. And I'm going to go ahead and pass it over to you, Annette. Thank you so much for being here tonight. I thank you from the bottom of my heart.
Well, I'm so happy to be here. My daughter had um, seizures that were intractable at the end. We tried, at least at the time, pretty much any and all the medications that are out there. So this was our life. This isn't just theory for us. This was our life. I have an extensive estate and special needs planning presentation. So I'm going to be looking at my slides, but I'm not going to be sharing them with you because I'll be picking and choosing, to sort of get to a framework of some of the basic tenets and some of the basic documents for a special needs plan. I do really want to make this presentation about you and what you need. So please don't hesitate to throw questions up or to interrupt me. I'm going to try to speak rather quickly so that we have a lot of time for discussion. I've been doing this a long time, and the presentation hasn't changed that much over the years because estate planning hasn't changed that much over the years. But what has changed are people's questions and concerns. And so, in order to honor this time with you, it's precious time. I would like to make sure that we have lots of time to talk. And so, please feel free to speak up. All right. So, I like to start with, what is an estate plan? Like, basically, why do we plan? So, estate planning really started out as a process for managing the title to assets when people died, and also who paid the debts of people when they died. And it grew from there to making sure that assets benefit you and your loved ones, anybody that you wanted to benefit from your estate plan, to also making sure that the right people are in charge of you and your family when, when the time comes. And for me, that's the part that really resonated with me, making sure that the right people were in charge. When I meet with families, they're not usually coming to me and saying, I'm worried about tax planning, or I really want to make sure that, we've given the right amount to the right people. They are more concerned with, especially our families, how are people going to be okay when I'm not here to take care of them anymore? And sometimes that's how are they going to be okay financially? But sometimes that's how are they going to be okay because someone needs to make choices for them. Someone needs to make sure that, their rent is paid and so on. So that's really what estate planning is all about. If you don't plan, you don't get a say in what happens to your people and your assets when you are either incapacitated or you die. A probate court judge gets a big say in what happens to your stuff and your people. People that you don't want or don't know may be put in charge. Your legislature has a big plan that they're happy to foist upon you. Assets can end up with people that you don't expect, and there are opportunities lost to protect assets and possibly save on taxes. So what are the most common types of documents that we would use in an estate plan for families like ours? Everybody's heard of a will. That is probably the least important document that you'll sign. You still need one, but more important, you'll be working with trusts, special needs trusts to be exact. Powers of attorney, healthcare proxies, HIPAA authorizations and releases, and guardianship and conservatorship appointments and nominations. Those are the general estate planning documents that most of you will have in your plan. So as I'm talking about planning, I am mainly talking to parents in this group. And so I'm going to be talking about an estate plan from your perspective that protects and supports you and your family. So first and foremost, we look at something called incapacity documents. It's just like what it sounds. If you are unable to make your own decisions, how do we have someone step in to support you? Incapacity documents are generally four things in your estate plan. They're going to be something called a revocable living trust, which we'll talk about for a few minutes, a durable power of attorney, a healthcare proxy, or a durable power of attorney for medical decision making, depending on what your state might call it, and HIPAA authorization and release. So, what is a durable power of attorney? Well, first and foremost, you should know that it is a present power concurrent with the principal or the person who's signing the document. That's you. That means that it's not a document that puts somebody in charge instead of you. Now, if you are incapacitated, of course, that person can step in when you can't make decisions for yourself any longer or manage your finances. But you can also have somebody support you through a durable power of attorney while you are still making your own decisions. That's what concurrent authority means. It also means that the principal, you, the person who's signing the authority, giving the authority away, can revoke it or can overrule the agent that you've nominated at any time. So again, it doesn't mean that people have the authority to override you and make decisions that you wouldn't make for yourself. The authority ends at the death of the principal. So this is a helping document while you're alive. it doesn't require you to be incapacitated. When you sign the document, it gives immediate power and authority. It's very rare that you're going to see a power of attorney document that springs into effect upon something happening, like you becoming incapacitated. It is most, oh, I see somebody's kitty. Hello. I love that. This is one of the best things about Zoom meetings. Okay, so and my dogs are at my feet, by the way. So this power is generally going to be present right at the time that you sign. So that's important to know as you are thinking about who am I going to put into place. Am I okay with the fact that they could actually go to the bank right away and withdraw money with this power of attorney? It's an immediate present authority. Now, most powers of attorney are cookie cutter, meaning that you can pull one off the internet, you can find a form somewhere, and even many attorneys will actually just have a form that they put names and addresses into without really thinking about what key powers would a family like ours need, where we are taking care of not just ourselves, but our entire family that with our children may extend beyond age 18, may extend well into their adulthood, decades into their adulthood. So you want to make sure that when you are doing planning and using documents that you are really individualizing your plan and making sure that you have everything you need in every document. So durable powers of attorney are generally over financial decision making, although sometimes in some states you'll see something called a durable power of attorney for medical decisions. In Massachusetts and in many states, this is called a healthcare proxy. Healthcare proxies are durable powers of attorney for medical decision making, are very different than the durable powers of attorney for financial decision making, especially in the fact that they are springing powers. Only a doctor can decide that you are not able to make medical decisions for yourself. And then they will do what they call invoking your healthcare proxy or your medical power of attorney. This is very important to understand for those of us with adult children who we may be also using these documents for, okay? This document doesn't take away our authority to make our own healthcare decisions until a doctor decides. I'm repeating it because it's important that we are unable to make our own medical decisions. Okay, and then they have to officially invoke this document and enter it into our medical record. This power of attorney or this healthcare proxy can be invoked and then can also, go away, can be taken out of your medical record because you have regained capacity to make decisions. And sometimes, and this can be true with our children if we are using these healthcare proxies to assist our children in decision making, sometimes we use these powers of attorney for complex decisions, but not everyday decisions. So let me explain what I mean by that. Let's say that you have an adult child with disabilities and regular everyday decisions, like they have a sore throat and, their doctor wants them to start on an antibiotic. Those are decisions that they can make together with the doctor themselves. But then something devastating happens and they need surgery or they need treatment for cancer or something complicated like they want to enter into a medical trial for a new drug or a new treatment protocol for epilepsy, say. It's possible that a doctor could decide that this specific treatment plan is more complicated than our person is able to decide. And they can use this medical power of attorney or this healthcare proxy to invoke just as to that specific treatment plan or that specific surgery, etc. So it can be that sophisticated. We can have a healthcare proxy that is valid for a specific event or time. Now, most states have these generic hospital fill in the blank type forms, and frankly, for 99% of the cases, they are fine. You don't necessarily need an attorney. If you have a very complicated situation, which a lot of our situations are, and you're concerned about certain types of decision making and certain types of treatment plans, you may want to get more sophisticated in your healthcare proxy document. But again, 99% of the time, that fill in the blank form that you get from your state or your hospital or your doctor's office is probably going to be fine. So when does this power of attorney end? It ends when the doctor says, hey, this person has regained the ability to make their own medical decisions, or the person dies. Again, it is for while someone is alive, the agent will be making decisions for the principal. It is not a helping document because it is either the principal is making their medical decisions or the agent is making their medical decisions. Now, we also use something called a HIPAA authorization and release. And we've been doing this since the HIPAA law was passed in 2003. So it's been well over 20 years now that we've been talking about medical records and medical information releases. And many people will ask me, why do you need a HIPAA authorization if you already have a healthcare proxy or a medical power of attorney document? Sometimes your healthcare proxies and your medical power of attorney document, not usually the fill in the blank form, but a more specific attorney drafted form, will have language in there about releasing medical records. A HIPAA authorization and release, though, is different than a healthcare proxy document. A healthcare proxy document is nominating an agent to make decisions for you. A release and authorization is not a springing power. It's effective immediately upon signing and can nominate more than one person to be able to share information with your doctors, but not making decisions. So there are times when we have more people on a HIPAA authorization and release than we would have on your medical decision-making document. And this document is a very effective supporting document because, just to give an example from our own types of lives, we need to get on the phone with a doctor's office to schedule appointments. Even that is a protected activity when it comes to medical protection of medical information. Also, we may have questions for the doctor about a medication that they've authorized, or we may, want to get a second opinion. So we may want to get into the patient portal to be able to share information. That means that your healthcare proxy or your medical power of attorney does not need to be invoked in order for you to be able to share information with the doctors, speak to the hospital, and review the medical record. I hope that makes sense to everybody. So we need both. We need both a healthcare proxy document and a HIPAA release and authorization because they stand alone and are separate. Okay. I'm going to stop here for 1 second. Does anybody have any questions about those documents before I move on to trusts and wills? There's only 15 of you, so if you want to raise your hand or just unmute yourself, feel free to do so. And if not, I'm just going to move on. Okay. All right. So what is a will? What does a will do? I mean, everybody who's an adult has pretty much heard of wills. And when you mention estate planning, a lot of times that's the first thing that springs to people's minds. Oh, it's about my will. Well, the will does really two things, generally speaking. It nominates an executor, or in Massachusetts, we call it a personal representative, to be sure that the terms of the will are followed. And then it specifies distributions of your stuff when you die. Essentially, it orders the changing of title or the ownership of your stuff, whether that's a bank account, whether it's a baseball collection, whether it's a baby grand piano. It's everything that you own. Now, surprisingly, a will, though, will only be in charge of assets that are individually owned or that go through something called probate or the probate process in court. So, for many people, avoiding the probate process is really like their most important estate planning objective. They will often come to us or go to their attorney and talk about avoiding probate. I've heard that probate can be awful. And really, it's more nuanced than that. It's more important to think about planning to maximize your odds of getting the most of what you want in your estate plan. It's really setting those goals and then using the documents to get there. So if you follow that rule of using your estate plan, including your will, to get what you want and employ these documents to get you there, that, it may follow that we're going to avoid probate as one of your goals, but it's not necessarily going to be the most resounding goal of your process. So let me just elaborate on that a little bit. Let's talk about what the probate process looks like. It's a court process by which we do two things. We notify creditors of debts that you owe at your death, and it transfers title of your stuff. But going through this process, it starts with a petition in the court to take your will, or if you die without a will, to administer your estate, and appoints that executor, right? Somebody nominates the executor, whether it's in your document, in your will, or if you don't have a will, somebody will nominate through the court petition who the executor should be. And then it marshals all the assets. So it figures out what stuff do you own at your death and what stuff needs to change ownership, to change title. Gives that notice to both creditors, but also your heirs, people that you've named in your will, but also people who are named by law as heirs. And then if there are any income and estate taxes due, that will get paid during the probate process. You pay off the debts of the decedent if there are any. And finally, you're going to make those distributions to the beneficiaries per either your will, or if you don't have a will, it's going to go by law. Okay. So what assets then are going to be governed by your will? What assets are going to change title through the probate or court process? A will may control some or all or even none of your assets at your death. It only controls whatever assets are held individually by you when you die. So to get more specific and to really understand this better, it's actually easier to think about what assets don't go through probate, don't go through the court process. It's easier to actually define those. And hopefully you are going to have a probate avoidance goal as part of your estate planning process, because it is a pain in almost all states and can be expensive and take a very long time. So Non-probate assets are assets that are not going to be governed by your will or by the estate administration process. Are, for example, any jointly held asset. So a bank account that has two people's names on it. In the old days, this was the estate planning tool that people used, not documents. I'm Italian. I come from an old Italian neighborhood in East Boston. And all of the old Italians in our neighborhood would divvy up their assets or their cash in bank accounts, and they would put names on those bank accounts and say, okay, so this bank account is for me and Francis. This bank account is for me and Giuseppe. This bank account is for me and Mary. And they would look at that as their estate planning model. When you die, owning a joint asset, the other owner still owns the asset. It doesn't get controlled by your will. It only will go by will if there's only one owner of the bank account. Now, this isn't a very good way to plan. It's old fashioned, and you can already probably be thinking, well, let's say that they decide they're going to put $10,000 in 10 different bank accounts, and that's how they want to pass on or have their family inherit their assets, right? But then they start needing to spend down those assets and they start pulling money out from this account and that account, but they're not doing it, they're not doing it equally. So now Francis ends up with $1,000 and Mary has $9,000 and, Julio or Giuseppe has still $10,000 in their account. And the assets don't actually flow equally, which was the original goal of the estate plan. I have 5 kids and 5 grandkids, and I want everybody to get an equal share of my estate, 1/10. But because they didn't monitor each of those bank accounts and make sure that they all had the same amount when they died, and nobody knows the day of their death, so it makes it kind of impossible to divvy things up right at your death, then sometimes the estate plan doesn't go the way that you want it to if you're using joint asset ownership. The other thing that people are pretty familiar with are assets that have a death beneficiary designation. We call those contract assets. So that would be something like life insurance. Your life insurance policy names a beneficiary when you die. That contract asset has already decided where that asset is going to go on your death. It's not governed by your will. Okay. Same thing with a bank account that you have either a pay on death or a transfer on death contract with the bank. So some accounts can have a beneficiary listed for when you die. And then that owner, by contract, will take over that account. And one of the most famous accounts that you can use will be a retirement account, either a 401k plan at your work, a 403b plan, or if you've rolled that over into an individual retirement account or an IRA, that's one of the more famous kinds of accounts that is a contract asset and has a named death beneficiary designation. Now, part of your estate planning is making sure that all of your assets are titled properly so that they don't end up, not uniformly benefiting different people, right? And so that you don't forget who your death beneficiary designations are, and those contract assets go where you didn't intend them to. So let me give you a for example. Through the years, I've had way too many cases of people who have had a life insurance policy since they were a young person, through their job or something, and they named their parent instead of their current spouse or their kids as the death beneficiary designation. They never went back and changed it. They just forgot about it. And I've actually recently had a situation where a couple got divorced and there was a death beneficiary designation that had been on there for decades, since before they were married, of parents of the original account owner. And the parents had a dispute with the divorced spouse and kept all of the money and didn't give it to the divorced spouse, but also not to the disabled grandchild, where the money was really intended to go. And just said, oh, we're going to hold on to this. And if he or she needs anything, we'll take care of it. But essentially, it's their money to do with what they want. And when those folks die, those assets are going to be inherited per their estate plan and not necessarily go to this disabled grandchild. Certainly, this parent absolutely wanted those assets, not necessarily to benefit the divorced spouse, although in this case, they probably would have, but certainly they would want those assets to go to support their disabled adult child. But that didn't happen in this case. And I have many more stories like that. Now, the other types of probate assets, I should say, I'm sorry, non-probate assets or contract assets, are anything that is owned by a trust. And that is really the crux of what we're going to talk about for the next 5 minutes before I stop to take more questions. Assets owned by trusts are not going according to your will. They're going to go according to what the trust document says. That's going to be the flow of ownership and management. Okay, so that is why trusts are going to be important, even in an estate that doesn't have a lot of assets. In fact, I argue that the smaller your estate is, the more important your assets, your documents are to make sure that your assets benefit who you want them to. And the more important your planning is to make sure that you've looked at all of your assets, including your contract assets, and that they're going in the right direction or to the right people or being managed by the right people. Okay. So what is a trust? Well, as I said, it's not just for the Rockefellers anymore. These are not documents for the wealthy. Certainly the wealthy have sophisticated trusts and estate planning. But in our situation, we're really looking at two types of trusts. We're looking at a revocable living trust to help manage our assets during our lifetime, and then disperse those assets to generally our kids. And we're looking at special needs trusts. Now, some people cringe at the term special needs. And I will tell you that for a long time, we've been talking about language. Special needs planning is really a term of art in the law, because Social Security rules and Medicaid rules, Mass Health in Massachusetts, use the word special needs trusts and special needs planning as a term of art. For now, we really can't move away from that terminology. So you'll hear me using special needs and disability pretty much interchangeably, and maybe you have different, verbiage that you like to use, but don't get offended with the terminology when we're talking about planning. So what can trusts do? Well, we've sort of talked around that a little bit, but they absolutely can avoid probate if they are funded. That means that the trust itself actually has to own the asset in order for it to be controlled by the trust document. Call that funding your plan. It can manage assets during your lifetime and long after you die, because a trust can go on and on and on. It's like a company. It can offer asset protection if that's one of the things that you're looking to do. It can protect irresponsible or vulnerable beneficiaries, something that's near and dear to all of our hearts. It can, in some cases, reduce estate taxes or do tax planning, can plan for long-term care needs, or it can plan for a person's access to public benefits, which is one of the reasons that we use trusts. It can even provide for charitable intentions, and it can do more things than that. One of the biggest decisions that you will make when you are planning with trusts is who is going to be the trustee. And oftentimes, you're looking at family members and friends, but don't rule out the idea that it might be a good move in your family to have a professional or an institutional trustee, like a bank or a trust company. All right, revocable living trusts are how we manage our assets during our lifetime. Anything that is owned by our revocable living trust is not going to pass through probate. So it's a good probate avoidance technique. It also reduces or eliminates estate tax for married couples. And during our lifetime, it can manage assets if we become incapacitated in a more acceptable or more centralized way than trying to use a durable power of attorney. We still need durable powers of attorney because not every asset is going to be owned by your revocable living trust. Think about those contract assets, like your 401k plan. That cannot be owned by a trust, but it does have a contracted death beneficiary designation. So the person who's holding the power of attorney as your agent may need to step in during your lifetime to manage those assets that are not owned by your trust. So you have a trustee of your revocable living trust and an agent under a power of attorney, hopefully the same person, or if not, at least working together to manage different types of assets while you're alive. The revocable living trust can be extremely flexible. If you can dream it, we can draft it. Although that's not always the best, planning technique. You don't really want to get too complicated in your plans, but it can also provide for asset protection for your children or your beneficiaries. You cannot use a revocable living trust to provide for your own long-term care asset protection. Okay, so you can't use an RLT to do Medicaid planning and access public benefits for yourself, but you can give that asset protection to your heirs through your trust, your beneficiaries. And again, this is an overview presentation. So I give these presentations over 2 hours, and then I can go into a little more detail about how those planning techniques are used. But just know that you're likely going to be talking to your estate planning attorney about a revocable living trust because they do so many great things. What they can't do, besides not providing asset protection for you, is they can't save estate taxes if you are not married, if you're a single individual, and it can't protect for long-term care needs for yourself as well. Okay, special needs trusts. There are 2 types. They're like vanilla and chocolate, right? We've got a third-party special needs trust that's funded with other people's money. So generally speaking, if you are providing for a family member who's disabled, you're going to be using a third-party special needs trust. And those trusts are so much better than a first-party special needs trust, one that protects the disabled person's own money, so that they still have access to public benefits. So let's talk a little bit more about those differences. What makes a special needs trust so special? So generally speaking, the person must have a disability. If it's a third party special needs trust, they don't have to be Social Security definition disabled. If it's a first party trust, it they absolutely do need to be Social Security disabled. They don't need to be receiving Social Security, but they do need to be Social Security disabled. It is going to protect a person's access to public benefits because assets in both types of special needs trusts are not countable for public benefits purposes. It's important that there is what we call a wholly discretionary distribution standard. Okay, that's a mouthful. But what we're basically talking about is the trustee, the person managing these assets within this trust document or these trust accounts, they have sole and absolute discretion over every distribution. That means that your beneficiary doesn't have any demand right. They cannot force a distribution. They could be, and this is the thing that gives everybody pause, starving and homeless in the street, and your trustee can still refuse to distribute assets from the trust to benefit them. The only reason that these trusts work for public benefits purposes and even for asset protection for third-party trusts is because these assets cannot be demanded. That means that your beneficiary has no control over the asset. That lack of control over the asset is what makes it unavailable to support the beneficiary by law. Okay? I know that's a lot, but sometimes in a traditional trust, not a special needs trust, you'll see language like health, education, maintenance, and support. That creates a demand right. It sets a distribution standard in your trust document that your beneficiary can enforce against the trustee. The trustee doesn't have sole and absolute discretion. They have to maintain that standard of support. So what is in your special needs trust really matters. Most of us, our primary goal of using special needs trusts is to absolutely have this trust be not an available asset for public benefits purposes. We want to be able to leave some money to supplement what the government provides. The government's never going to provide enough. But if we didn't use government benefits, most of us don't have enough money or enough assets to provide for another person's lifetime. Okay. So that's what makes a special needs trust so special, generally speaking. Anyone can establish a third-party trust. It doesn't have to be a parent. It could be a grandparent. It can be a neighbor. It can be someone that you go to church with or temple with. But a first-party trust has very specific rules about who can establish it. It can be the disabled person themselves, a parent, a grandparent. It can be established by a guardian, or if you don't have any of those people available to be able to establish a trust, it can be established by court decree. A first-party trust has something called estate recovery, and many people will hear this in passing about special needs trusts. These are only when you are planning with assets that belong to the disabled beneficiary. If you are the parent and you are planning for yourself and your family, you're generally using a third-party trust that will not have payback. That means that when your disabled beneficiary dies, whatever is in that trust will go to the next level of beneficiaries, maybe your other kids, maybe grandkids, maybe charity, that you decide and you designate. So what does a trustee do? What are their responsibilities? They invest and manage the assets. They distribute them in accordance with the trust document and with the state law. They keep the books and records. They file a tax return for the trust, and they can also hire advocates and case managers, etc. Okay. I just want to very briefly mention able accounts, and then I'd like to take the questions. Able accounts are not trusts. People do get very confused about this, but they can be super helpful in planning. All right. They have very specific rules that govern how they operate. They also have payback provisions. Generally speaking, we're not talking about funding able accounts with a third party's money. We're talking about establishing able accounts with the disabled individual's own assets or money. You do need to be disabled prior to age 26, but starting in 2026, next year, that age actually goes up where disability must have been established prior to age 46, which is going to be extremely helpful for a lot of people. And there's a contribution limit each year, as well as the total amount of assets that can sit in an ABLE account. You should be, in most cases, using ABLE accounts along with your estate planning tools and your trusts. All right, I know that was a whirlwind, 2 hours of presentation in 30 minutes, but now let's look at your questions and let's talk about some specific things that you really are thinking about.
I believe we have a question from Monica. Monica, did you want to unmute yourself and ask your own question, or would you like me to read it for you?
Let's see here. Hi. Um, I'm Monica. I am 43 years old. I have a complex syndrome of epilepsy called Dravet syndrome, which not many people know about. Which was diagnosed by a genetic study I took about a year ago. Had this since under age 1. I am quite, however, independent physically. I drive a car because I'm well medicated. I had some stable jobs, but they were always intellectually different than like the rest of my family members. Like I come from a family of doctors. I would have a low income paying job such as retail sales. Um, but being stable. And then now I'm on Social Security disability, working under 10 hours. My life has changed. I was just in a car accident yesterday. Um, how I have trouble also with math, with school. I also have trouble like with spending, managing money, budgeting. It was always a problem for me. What do you recommend for someone like me who wants to strive to be as always as independent as possible, but has limited abilities with like math and saving and what you talked about all the law enforcements, like I have a health care proxy. We do have a trust. My parents do manage my banking for now. So like I'm stable in that sense, but like I want to be as independent as possible, if that makes sense.
Mm-hmm. Well, I can't really give you individual advice because I obviously don't know enough about you in that 2-minute recitation to be able to weigh in on, what kind of documents you should be using. It sounds like you're on the right track, that family members who may want to leave you money when they die or give you money during your lifetime are managing it through third-party documents, which is great. It sounds like you've already chosen trusted advisors to step in and support you with your financial decision making and financial management.
They decided more than I did, but yeah, I kind of want to break away from that a little bit if I can, but
If I were you, whoever is advising you and not your family, but you, would be important to look up ABLE accounts and the rules about ABLE accounts, because an ABLE account is your bank account, but you can designate a helper person, but it's still your account and you are the primary
So
manager of
that's
that.
like a bank account where I put money
It
in
it
and
is, it is. It's
okay,
man,
so that I think I have because I have a bank account. Like I live alone, so all the payments for the housing for the cars all in there under my dad's name, but my name is in there too. It's designated to me.
so I think it's important to just make sure that you actually do have an ABLE account because ABLE accounts are very specific and they can only be managed by an agency that has been designated as an ABLE account, vendor.
Mhm.
So it may not be specifically an ABLE account. It may just be a bank account that you've either put somebody's name on or they're managing it
Okay,
with a power of
okay, so it's
attorney.
different.
So I think you've got a lot to unpack there, and I think it's important that you get your own advisor. Okay, if not an attorney, then at least somebody who's a financial advisor or someone through an organization that has volunteers that can sit down with you and make sure that the plan is appropriate for you and for what you want.
And is that like free or is that like
It depends. It can be, as I said, there are organizations that have volunteers that can help with
uh-huh.
these sorts of things.
Okay, gotcha. Thank you.
What state are you in?
I'm in Massachusetts also, yeah.
Okay, all
Yeah.
right. So there definitely are places you can go. You can call the Disability Law Center. You can, I see that Christine put the ARC on here. The ARC may be able to make a recommendation for you. There
Oh,
are free and low cost supports through legal aid organizations for people with disabilities who can get some help with some estate planning. Okay,
okay, thank you.
of course. Any other questions? Feel free to just unmute yourself and ask the question or raise your hand. Elizabeth?
Hi, yeah, my name's Libby. I'm here with my husband, Dave.
Hello.
Hi. We have a 27-year-old son who became ill with a severe an autoimmune encephalitis back when he was 14. But anyways, it left him totally pretty much dependent on us. And he has refractory epilepsy and like you were talking about, tried every drug, have done this, done that. He's going to have RNS, deep brain surgery next week. He has a
Mhm.
VNS. But, anyways, our problem, or at least for me, it's my worry that he doesn't have any siblings. He's an only child. We have like one niece who's in her 40s who really loves him and would be in, I've asked her, she's not married. She doesn't live that far away, maybe an hour and a half, that she might be somebody who could possibly be a trustee. Um, but he's in adult services in Manchester, New Hampshire, and we live in New Hampshire. So we still haven't gotten a special needs trust set up. We're still looking for guidance, I guess, who would be a good special needs person, lawyer, in New Hampshire. And if you have any suggestions, we'd be welcome to that. But do you ever hear of anybody using an adult service like
Caregiver.
his caregiver he's had for 6 years now? And I mean, we haven't broached the subject or, but does anybody ever ask their caregivers? I mean, this couple knows him the best.
Mhm.
And I don't know if that's ever anything we could even, if
So,
that's
so
legally
let me
allowed.
just say, Libby, that usually is a conflict of interest if there's a
Yeah,
paid caregiver.
right,
For them to also manage assets for the beneficiary, be their power of
right,
attorney agent or a trustee. So
right.
usually that's not going to be a good fit.
Okay,
But I would say that it's very important to meet with a qualified estate planning attorney in or financial services person in
yeah,
your state, in your area, to talk over specific rules. And to the extent that your son can participate and make his wishes known, I think it's
Yeah,
really important that
yeah,
he's included in the planning, especially
right,
around selecting supporters. So
right.
these are complex issues that really are difficult. I meet with many families who either don't have people or are concerned about overburdening people, but
Right, yeah,
you don't want to leave that to chance. Sometimes a family member is not the best option. Sometimes you
yeah.
need to look at professionals. So I
Yeah, so
think
maybe a bit like a combination, even like my niece and a and a bank, like bank does the payments, part of it. I don't even, that's
so you're gonna if you do your estate planning right and you have a good planner or a good team, you're going to end up with a team to support
okay,
your adult child, right?
okay,
You're going to have some professionals in place, you're going to have some clinical people in place, you're going to have some financial people in place. They're not necessarily all going to, they're not going to be like one person or, one institution that does everything. You're going to have maybe, the right trustee is maybe going to be a professional, and then the right guardian or the right healthcare agent is going to be a family member. Though there's a lot of decisions that get made in estate planning, and that's why it's important for you to think about this as a process and not just a set of documents. Documents can look very pretty, but if you don't know what they're doing in your plan and you haven't tied your assets to them and you haven't done a good job of setting up that network of your team
yeah,
to carry
yeah,
on after you, then all you have are pieces of paper. So
right,
getting with a good planner is important, and I'm glad you raised this issue. If you go to NAELA.org, so that's NAELA, National Academy of Elder Law Attorneys, they have disability attorneys throughout the United States, and those people are specially qualified. Of course, you want to make sure that you interview some people and get the right fit for you. It's NAELA, not NELA, NAELA,
okay,
NAELA.org, National Academy of Elder Law Attorneys. There's also the Special Needs Alliance, which also lists out specially qualified attorneys. So Special Needs Alliance. Um, so those are two places you can go for recommendations. Okay.
okay.
All right.
Thank you.
Yes. Let's see. Was there another question in there? And then I think we need to sign off. How early can you start an ABLE account? My daughter is still young, 11 years old, and has epilepsy, but also has other underlying medical conditions. So there are very specific rules about whether she meets the definition of disability, but generally speaking, you wouldn't start saving in an ABLE account now, because if your daughter passed away and there was money in that account and she's received Medicaid services throughout her short life so far, then that money would end up being, going back to the state to reimburse for the medical expenses that Medicaid is paid for. So you don't want to take your money and put it into an ABLE account. That's not a savings vehicle for you to provide for them. That is, generally speaking, a vehicle for the disabled person themselves and their own money. It's complicated, and again, you need to sit with a qualified planner. This is so important. You've got to find a good planner in your state, because again, it's more than just the documents. I know we've had such a short time today to just go over some of the basics. There are, if you go to my website, I have a very affordable estate planning course that goes into a lot more detail. It's, this is not a commercial for me, but it is, a fraction of 1 hour of sitting with an attorney. And it's a good way to educate yourself a little bit more about the estate planning and special needs planning process, and going deeper into the documents to get yourself ready to be able to partner with an estate planning attorney to get a plan in place that meets your goals. okay? So if you go to one of our websites, I think Christine can provide those for you. You can look and see if this is something that maybe you would want to invest in. Again, it's a fraction of an hour of my time, for example. So it's pretty affordable to be able to do that. And I want to make sure that people have the proper education to be able to put a good plan in place.
Annette, as we end today's webinar, one last question. What if a family cannot afford an attorney? What if a family, can't afford the cost of going to an attorney and doing the special needs estate planning? Do you know, are there like nonprofits in states that would help with that, some of that you know of? Because I know that a lot of our population, we just have, especially in today's world, people are struggling, but wanting to still making sure that their loved one that has disabilities is protected. What would you kind of give advice for those that are kind of struggling,
So
want to do
for
this?
sure, there are definitely people who are at different fee levels and fee structures. I will say that this is one of the places where you are going to want to invest. Okay. You should, maybe find a payment plan. Some people's work have insurance or legal plans that they can pay into that will help pay some of the legal costs. Maybe not all, but some. So look at your employer and see if you have a legal plan available to you. That could be helpful. There are definitely nonprofits or volunteer organizations that you can go to. They vary from state to state, but start with your state legal aid or your state ARC to ask about that. And there are many attorneys who will work on a sliding fee scale for people that really need to get their planning done, but don't have a lot of assets to plan with. So I think it's important that you start gathering names and just go through the process of interviewing people and interviewing organizations to see what would work for you.
Well, thank you so much, Annette, for joining us tonight and enlightening us with all this information. This recording is going to be available for everybody, so you'll be able to get a copy of this recording, which will be great. I do just want to say thank you again to Annette that had been with us, and I will stop recording.